Welcome to this overview of mediation in criminal matters. I'm Dr. Timothy Hadeen. I'll be presenting an overview of the history, development, and practices of mediation in criminal contexts. This video is part of a project funded through the American Bar Association's Enterprise Fund, jointly sponsored by 8 entities within the ABA: the Criminal Justice Section, the Section of Dispute Resolution, the Section of State and Local Government Law, the Standing Committee on Legal Aid and Indigent Defense, Government and Public Sector Lawyers Division, Commission on Domestic Violence, Commission on Effective Criminal Sanctions, and the Judicial Division. This video seeks to present some of the history of mediation in criminal matters, and will then transition through some of the contemporary state of the field, and will conclude with an actual mediation demonstration from some colleagues. Two of the earliest instances of mediation in criminal matters occurred in the early 1970s. The first was in Columbus, Ohio, termed the Night Prosecutors Program. This program responded to minor criminal complaints in which the parties would have some ongoing relationship or reason for future contact. Parties would come together at the courthouse in administrative hearings conducted by a law student overseen by a prosecutor. During these hearings, victim, offender, families, neighbors, other interested individuals would speak about what had happened and what would be an appropriate response for this. The program relied on opening these channels of communication in order to respond to the issues between them. The program was met with remarkable success. Only 2% of the cases resulted in the filing of a criminal complaint or an arrest warrant, and in only about 3% of the cases did the complainant bring a charge against the same party at a later time. Another notable development occurred in Elmira, a small town in Ontario, Canada, in early 1974. In this case, two young men, quite drunk and quite angry, went on a vandalism spree, slashing tires, damaging boats parked on trailers, even tearing the cross off of a church sign. When it came time for the sentencing hearing, the probation officer assigned to deliver the pre-sentence report recommended that these two young men actually meet with the victims of their crimes. The judge agreed with this sanction, gave them 3 weeks to complete this stage. Without any preparation or much less a script, parties went forward. The probation officer and the two young men knocked on the doors of the victims, and when the victim would answer the door, would explain, "We're the perpetrators, here to find out what we've done." It took 2 nights to track down all 22 of the victims and arrive at some assessment of the damages. That report was delivered back to the judge. The judge sanctioned that they would have 3 months to complete all of those elements. Sometimes this was worked off through repairing the damage done, welding the cross back onto the sign, patching fiberglass holes in the boat hull. Otherwise, it took the form of cash to repair a car's radiator or slash tires. One noteworthy encounter is recalled by the probation officer, who remembers a woman having accepted the check from the perpetrators, commenting to them, "Please understand that at this point, we're straight. This is Elmira. It's a small town. We all shop at the same stores on Main Street. When you see me on the street, please come up and shake my hand, because you're clear with me now. I don't appreciate what you did. I don't think it was the right thing to do, but as far as I'm concerned, you've repaid your debt." Both of these examples involve a reconceptualization of justice. In his 1990 book, Changing Lenses, Howard Zare proposes an alternative framework to understand how justice may respond to a criminal act. On this chart, we can see some of the distinctions he draws. In a retributive justice framework, crime is a violation of the rules, the state is the victim, and the parties, therefore, are the state and the offender. In a restorative framework, crime harms people in relationships. The victim is a person, and therefore the parties are the victim and the offender. On the needs and rights of the participants, in a retributive framework, a wrong, committing an act that's wrong, produces blameworthiness, and the focus of criminal trials, and the retributive framework approach, would be the mark of guilt. In a restorative framework, a wrong act produces an obligation to the victim, and the focus is on repentance and repair. Debt is owed to society in the abstract in a retributive framework. Debt is owed to the victim first in a restorative one. Finally, debt is paid by punishment in a retributive framework, whereas debt is paid by making right in a restorative framework. Another set of distinctions that are key between the retributive approach and a restorative approach would be about the process and outcomes regarding processing a criminal matter. The retributive framework is centered on fixing blame, and this is done through an adversarial process. The victim's rights and needs are secondary, the victim, him or herself, generally on the periphery of the process, if involved at all. Similarly, the offender has not an active role in the process, but sits and observes as charges are levied. Very often the offender, him or herself, is denounced instead of the harmful act. In a restorative process, on the other hand, focused on problem solving, dialogue facilitates an opportunity for the victim and offender to interact, allowing the victim's needs and rights to be considered fully, and the victim having an active role. The offender is held responsible, but also has an active role through the dialogue-based process. The act itself is denounced, not the offender. This provides opportunity for repair between the parties themselves and restoration of the victim, the offender, and hopefully the community. The mediation of criminal matters is often termed victim-offender mediation, which, to borrow language from Mark Umbright, provides interested victims the opportunity to meet the offender in a safe and structured setting, with the goal of holding the offender directly accountable for his or her behavior while providing important assistance and compensation to the victim. Instead of being settlement-driven, victim-offender mediation is primarily dialogue-driven, with the emphasis on victim healing, offender accountability, and the restoration of losses. A key distinction between mediation in criminal matters and most other forms of mediation is the role of preparation. Specifically, most mediations open with separate meetings. A national survey of victim offender mediation program found that a large majority employ the practice of meeting with each party separately prior to any joint mediation session. In these meetings, the mediator, or an intake staff member, would meet with the offender to ensure that he or she has taken full responsibility for the act and is willing to engage in constructive dialogue with the victim. In meeting with the victim, the mediator or colleague would work with the victim to ensure he or she is in a space to revisit the trauma or act of the crime and is prepared to engage in constructive dialogue with the offender about appropriate responses when available. While mediation in criminal matters is distinguished by the preparatory process, there are also some distinctions around the conclusion. The role of settlement in victim-offender mediation is a bit distinct. While most mediation concludes with an agreement, this agreement, however, is secondary to the importance of the dialogue between the parties. Several studies have consistently found the restitution agreement is less important to the crime victims than the opportunity to talk directly with the offender about he or she felt about the crime. The effect of any settlement reached in mediation depends upon the rules of court and the timing of the mediation. The slide reflects the findings of a national survey of programs in 2000. It's found that of these victim offender mediation programs, 3% offered mediation or conducted mediations prior to any court involvement. Over a third, 34%, employed mediation as a form of diversion. 28% used mediation post-adjudication but pre-disposition. 28% employed mediation post-disposition. And 7% of the surveyed programs indicated they offer mediation or conduct mediation at various points across the processing of a case. So what types of cases are handled through mediation? A national survey found that approximately 2/3 of mediations in criminal matters involve misdemeanors, the remaining third involve felonies. While mediation can be used across a wide array of charges and types of cases, the four most prevalent referrals include vandalism, minor assaults, thefts, and burglaries. A study commissioned by the U.S. Department of Justice found that an array of players within the criminal justice context refer cases to mediation. As this chart reflects, probation officers lead the way with nearly a third of all referrals, whereas judges account for almost a quarter. Prosecutors and defense attorneys represent almost a quarter as well, with prosecutors referring about 15% of the total pie, whereas defense attorneys refer about 7%. Juvenile diversion programs refer over 1 in 8 cases, whereas police officers accounted for 10% of the referrals. Community members and victim advocates also made referrals to mediation in criminal matters.